Okay, we've given you some overview of estate tax law, and we've given you some overviews of conservation easements. I'm going to give you a little bit more information about conservation easements to wrap things up, and then we're going to put this all together for you and show you how, similar to the example that Thomas gave regarding the meritable deduction and that being portable new in 2013, how a conservation easement similarly can be used to reduce estate tax and to provide some income tax savings as well. So let's see. A few more basics you may have picked up from earlier presentations. Landowners do have a lot of protection in these negotiations. All the restrictions are negotiated. You've been given some overview of some of the typical restrictions, but I loved the way David Hartman talked about the fingerprint. Each of these easements is uniquely tailored to the property and to the landowner, and so there is a good amount of negotiation that typically goes on. And the landowners continue using the property in the traditional ways. Usually they'll wake up the next morning after the easement is placed and they go about their day exactly as they have for years, using the property for agriculture, for recreation, for residential uses. There's no changes for them. And a very important point to make, there's often confusion in the public about public rights to property under conservation easement. You can provide, as David talked about in the public purpose section, you can provide for public access and public use for recreation and education. That is not required at all, though. There's no requirement for public access, and the public is not given any rights to property because it goes into a conservation easement. So the conservation easement is going to be attractive for people who want to keep their property in the family, who want to continue using the property the way they're using it. And from the land trust perspective, it's going to have some conservation values that the land trust is interested in protecting. And this ties into why they're typically going to be allowed a deduction for giving the conservation easement, because there's some public benefit that's been documented and valued in the Treasury regulations that David ran through for you. But often people are coming to us because of income tax and estate tax concerns, primarily estate tax. That is the major driver for us. And then usually, in order to make the numbers work, there's going to have to be some development pressure in the area. And I'm going to give you an example of this. So we haven't talked about valuation yet, but it's important to know about valuation because the value of the conservation easement for a donated conservation easement is going to translate to the value of the deduction. This is a charitable gift, just like giving a bag of clothes to Goodwill is a charitable gift, which is deductible against your income tax. If you're selling a conservation easement, then the reduction in value is going to be the purchase price, unless you're doing some type of bargain sale. So I want to let you know there are very general rules of thumb. For property that's very close to a city, we've seen conservation easement valuations in the range of 50% to 90% of the fair market value. Now, I want to tell you that 90% is an extreme. Please don't get too excited. We have seen an appraisal at that figure, but that is very unusual. I would say 50 to 60% is more typical. And for rural areas of Texas, 30 to 60% of the land's fair market value is more typical to see. Now, why would somebody do this? The reason that they're doing this is because they want to continue using their property exactly the way they always have, but the value of their property has changed over time because of the development pressure. So what they're trying to do essentially is to unlock that portion of the market value which is attributable to the development pressure and separate that. And when you think about in terms of estate taxes, you might have a property that's worth $7 million, very valuable because the home builders would love to get their hands on it and put in a subdivision. The family wants to remove that portion of the $7 million to take it back to the $2 million ranch they bought originally, whose highest and best use is for farm and ranch use and not for residential use. So they're trying to unlock that value that's attributable to the development rights that they don't intend to use, they don't want to see them used in the future. So here's a scenario to give you an example. This is a family client of the law firm, bought property in 1975 in Dripping Springs, paid $300,000 for their ranch, which was $500 an acre. The property value was really tied to and attributed to its use as a farm and ranch, recreational. There was not a lot of development going on in the area at that time, and the family was very happy with that. They had one house, they ran their cattle on it, and that was all they wanted to do. Fast forward to 2013, Dripping Springs has totally been transformed. If you put this property on the market today, it would be snatched up immediately and converted to a subdivision. You can see that because there's subdivisions, small lot subdivisions all around it. But this same 600 acres is being used in the same exact way. There's still the same house, the family's still living on it, they still have their ag exemption, they're still running cattle. Everything is the same for them, but they are looking at a huge estate tax burden, and they know that they cannot pay those taxes without subdividing the property. The appraiser who looked at it now in 2013 would put a much higher value on it because of this incredible development pressure which is attached to the property that the family has no interest in. So this is a long slide. Please pick up the handouts in the back, but some of the possible restrictions, and the ones that we almost always start out with are subdivision or partitioning, dividing the property. Building envelopes, as Burgess said, restricting the amount of development that can happen in the future for the property. I want to let you know that a landowner can use this subdivision term very creatively. They can say that there are minimum subdivision sizes as well as dictating how many subdivisions can occur. They can talk about maximum subdivision sizes. They can put the easement on part of their property but not on all of it. There's a lot of flexibility there. But the land trust is basically looking at the conservation values and trying to figure out what do we need to make sure does not happen on this property so that the conservation values will be protected in perpetuity, and then what's compatible for the landowner to continue to do. And you may very often have different phases for the property where you may have the building envelope areas where a lot of activity is permissible and maybe you can introduce exotic and non-native species, and then you have the standard treatment for the property, and then you may have the no development zones. Burgess talked about 300 feet from creeks, endangered species habitat. Maybe if you're protecting view sheds, you've got that view shed identified, but the no development zones are the areas that you're going to have the heightened restrictions, where building envelopes cannot be located, where you cannot introduce new species, where any clearing occurs by hand. Maybe it occurs in conjunction with the management plan that the land trust has some participation in. So again, a huge variety and ability to tailor these to the property and to the landowner so that you're able to protect the conservation values while permitting future uses for the landowner that are not going to cause problems there. And a few special issues that you need to be aware of. It's very important, it's required, and these first two here are from the Treasury regulations we've been speaking to. So there are specific concerns for easements that you are seeking a tax deduction for. If the property has a lien on it, it's always critical that the land trust run the title early so they make sure they're working with the actual owner of the land, that they know the boundaries of the land, they know what encumbrances are on the land, and they know what liens are on the land. It is required that the lien holder subordinate to the conservation easement before that conservation easement is placed on it. The reason this is important is that if the landowner ever fell behind on their mortgage payments, then because that mortgage was in place before the conservation easement, if the lien holder foreclosed on the property, it could extinguish the conservation easement. Remember, David Hartman told you that the conservation easement must be perpetual to be deductible. So you would not have met that requirement there with the IRS because the conservation easement could potentially be extinguished. So you must be careful to make sure you subordinate before the conservation easement. It's supposed to be contemporaneous. Severed mineral rights, we're all having lots of fun trying to figure out how to deal with this. But also very important when you evaluate the title early that you make a determination about if there have been any severances of the mineral rights, especially if executive rights are outstanding. If a third party has executive rights, then they can come on and use the property. And in Texas, the mineral interest is the dominant interest. It has the right to use the surface of the property. It has the right to use the resources of the property. So this is required by the Treasury regulations that if there's oil and gas production, it needs to be limited and localized. That's the language that we follow. And surface use cannot be permissible at all. And there may be a situation where there's a third-party mineral holder who has the right to come on and surface mine or do very aggressive oil and gas production. So the landowner has to be concerned because they may not have met the IRS requirements there. And the land trust has to be concerned because even though the landowner is promising never to do any of these things, there's a third party out there who has the legal right to do that. So please make sure you know the status of the title. And then grazing and property tax issues. We're often asked if the conservation easement will reduce property taxes, and the practical answer is no, because almost all of the landowners will already be in some category of 1D1 status. They'll either be managing their property for agriculture or for wildlife, and so they'll be paying their property taxes based not on their market values, but on the productive value of the property. However, it's true that this easement will decrease the value of the property, and that can be reflected in the appraisal district records. Okay, so using conservation easements, I want to bring this all together for you now to help you understand, and I think the short example from Dripping Springs helps you understand. For many families, the property that they're owning is their largest asset, their most valuable asset in their estate, and the conservation easement is a fantastic mechanism for the right family for decreasing the value of that asset and therefore lowering their estate tax obligations or potentially even eliminating them. So it's a great federal estate tax strategy for the right family, and it's also a mechanism for them to leave that legacy Thomas was talking about for the family that is feeling so connected to the land and wanting to continue that legacy for their children. One of the landowners we present with tells a little story, I love my kids, but I don't trust my kids. And so that's what he was trying to do, and that's what motivated him to donate his conservation easement. He thought it was more important to give his children the property than to give them as much money as possible. So think back on the pyramid at the beginning and saving the taxes to the greatest extent practicable. He didn't want to give them the most valuable asset he could, which was the property with the market development. He wanted to unlock that so that his grandchildren would be swimming in that creek the way he was, and the kids would not be scheming in the back about if it was going to Pulte Homes or K&B. Okay, and a contract or a letter of intent, this is a real estate transaction, and we will typically see in a donation of a conservation easement a letter of intent. It's a formal statement between the land trust and the landowner about what terms they intend to enter into. It's great for avoiding misunderstandings. You don't want to be in a situation where you've been negotiating a conservation easement for months and you find out December 1st the land trust thought the terms were going to be X and you thought they were going to be Y. So I like formalizing that and keeping it in writing. Or with the sale of a conservation easement, we'll typically see a purchase contract or an option contract. And these are important in the estate tax context because they are a contractual right, and so this is something that can be continued on by the executor to donate a post-mortem conservation easement. And I want to let you know that that is permissible. And some families will do the calculations after the death and realize that they have the option of either dividing the ranch to pay the estate taxes or doing a post-mortem conservation easement, and they can do that. Oh, I'm jumping ahead. And a really critical point to make today, whether you're a landowner yourself or whether you're here from a land trust, is to urge the landowner to get the next generation involved. You will almost always find that the next generation has some potential reserved rights in mind that they have not expressed to their parents. You don't want the children to be surprised by the conservation easement. Hopefully they will be on board, but a lot of difficult discussions that will occur in those early stages to make sure everybody is okay and on board with this, because this is not like a typical real estate transaction that you meet on the terms and you shake hands at closing and then you go your separate ways and never see each other again. There's going to be continuous involvement between the two parties after this. So the result after the easement, the land trust perspective, they're conserving the habitat or the water quality, the open space, whatever was that conservation value that was aligned with their mission that's so important for them. And they're doing it at a very low cost. They're protecting those conservation values without taking on ownership obligations of the property. They're not paying for any of the property if it's a deduction, or if they're purchasing the conservation easement, they're only paying for a portion of the fee. They're not taking on the ownership duties. They're not taking it off the tax rolls. It's a very cost-effective way for them to protect the property. For the landowner, they're getting hopefully some financial benefit, either some cash for the sale or the deduction for the donation. And they're still using the property just the way they wanted to, especially because they negotiated that easement to reflect their concerns. The land value will continue to appreciate. They can donate this property, they can pass it on, they can sell it on the open market. They've separated that value, unlocked that development potential, and they're enjoying the tax savings. And I want to tell you a little bit about living with an easement, because I said when you leave the closing, the relationship is just beginning. You're going to be working with the land trust, and the land trust will be working with the landowner and their future owners from forever. And so some of the things to expect to comply with. In many circumstances, we will be seeing the conservation easement limit development by using impervious cover. I personally like this because there has been litigation and disputes about trying to limit future development by describing the types of buildings or the types of uses. As an example, an early easement might say that within the building envelope, the landowner can build one residential home for one family and associated outbuildings to support the farming and ranching operations of the family. And then 10 years later, the family builds a barn, but on the top of the barn, they build a mother-in-law suite. Now the land trust is trying to figure out, well, that's really a second home. Is that permitted or not? And how much does it really matter that they did this or not? Well, they increased the value. Did they provide a private benefit? That can be difficult to determine how to proceed. I think the use of impervious cover limitations is a better tool. And when I say that, I want to let you know that what that means is that you're putting down something on the surface of the ground which is substantially impeding the water absorption. So this would typically apply to asphalt roads, but not roads that are 2 tracks. Certainly building foundations, sports courts, these types of things. That's a nice mechanism for limiting development. Annual monitoring. The land trust is going to come on the property at least once a year to monitor. I love Burgess's idea about checking in every 6 months, because you do want to have those discussions with the landowner about where they can build the barn before the barn's built. Land trusts don't want to have to knock down barns, but that has happened in this country. Exercising reserved rights. It is customary for difficult situations that you're not ready to pin down with specificity when you're drafting the easement to say that you can do this, but it's going to have to get land trust approval. And so it is typical that you will have to have some type of back and forth when the landowner wants to exercise those reserved rights. And then the enforcement potential. We haven't talked very much about this, but the land trust is on the hook to enforce the terms of the conservation easement if there's a violation. And there will always be provisions on how that should go. What type of notice will go back and forth? Will they work together on a restoration plan? Will they file for a temporary restraining order? But that is a very important role that the land trust is playing in protecting that public investment. And then, as I said earlier, the land can be sold or gifted subject to the conservation easement. So now you are really pretty up to speed on conservation easements as a whole, and Thomas is going to pull together for you the income and estate tax benefits.
Buckle your seatbelts. We have to go pretty quick here if we're going to get the landowners up on the stage. So we're going to talk about the income and estate tax benefits of doing this type of transaction. As has already been mentioned, they produce financial benefits in different ways. The one I want to highlight here is phasing in easements over multiple tax years. I did more of this in Colorado. I'm licensed to practice there. We had a large ranch that we chopped up into 3 segments, and we phased the easement in over multiple tax years. This extended the tax benefits. And in Colorado, there's also state income tax benefits and credits that are available, and so there were benefits at the state level from doing this. It has to have some rational basis. You can't just, do this acre by acre, but it is another tool that can be used. So there's a number of ways in which these financial benefits are realized, whether it's a donated conservation easement and you get an income tax deduction and therefore tax savings. In the estate tax context, the value of the property is lowered, and so you escape federal estate tax because the value of the gross estate is lower. There's also the 2031C exclusion, which we'll talk about in just a minute, that can also be used when you're calculating the taxable estate. It doesn't lower the value of the property itself the way an easement does. It's just a calculation mechanism that allows for a landowner to take an additional tax benefit if there's an estate tax issue. Obviously, if the property sells after the easement is in place, there's a lower capital gain tax because you've taken a property subject to the easement and you've created a benefit there. In some cases, there can be property tax relief, but not normally unless there's a rollback. Then it's very possible to argue to the appraisal district that instead of full market value, the property should receive a value that's lower than that because you've taken away the development potential. And this is very difficult for the appraisal districts. I don't know many appraisal districts where this would be successful, but at least you've got ammo in your quiver to make this argument with them. This example was introduced before, and in this case, it's a single doctor. Okay, so he's got a federal estate tax issue because he can only shelter $5.25 million at his death. And we're going to talk about the estate tax implications of the donation of an easement that's worth approximately 70% of that value, 69%. So this is what happens, and this kind of summarizes the cash. Now, you can never regroup what you've given away. Okay, you're never going to make yourself whole with these tax benefits. So it's not the economics that are driving these transactions, right? It's the desire for the landowner to protect the property and to pass it from one generation to the next. And reduce taxes might be in that mix, but it's going to be lower. But nonetheless, when you run the numbers, it's quite powerful how these things can add up. And this might be a tool to show to landowners if you understand how this is done. So let's look at it very specifically in terms of the income tax savings first. And for a long time, the last 8 years, these tax incentives have been in place that have brought a lot of people into the donation of a conservation easement. It's expanded the pool of people that can receive tax benefits. Even people of modest means can now receive more of a benefit as a result of these incentives. As you know, Congress reauthorized these incentives at the end of 2012. They made them retroactive for all of 2012. People who donated easements in the middle of 2012 thought that they weren't going to get these incentives, but they came back. So that's great. And they've extended them through 2013, and then they're scheduled to end. Okay, so you need to understand both regimes, the current regime, which has these enhanced tax incentives, and then what happens if the donation is made on January 1 of 2014, and we're back to the old law, unless Congress, again, reauthorizes these tax incentives. So in order to do this, we'll just run through an example. Let's say the doctor donates an easement in 2013. Well, he's a very successful surgeon. He's got a high AGI, adjusted gross income, that he reports on his income tax return. But he's in a very high tax bracket. Under the new tax law that was just passed, the high tax brackets were increased. So he's paying 39.6%. The value of the overall gift that he made, this $5 million donation, he can't take that all in 1 year. Instead, it's limited to 50% of his adjusted gross income in the first year, the year of the gift. So he'll be able to take bites of that $5 million over time, according to his adjusted gross income. If his adjusted gross income changes, so does the size of the bite, okay? So we're going to assume that his income remains at that high level for years to come. So what this does, when you reduce his AGI by this 50%, you've actually lowered the amount of taxes he's going to pay, right? He's in a lower tax bracket as well. So when we run the numbers, geez, I wish I could move that. Under the current incentives, he qualifies for the 50% AGI limit, and he can carry the remaining portion of that charitable gift forward and use it for a total of 16 years. Well, when you add up the tax savings on an annual basis, over the life of the use of that deduction, he can recoup about $1.4 million in tax savings. This is cash that comes back to him, cash that he doesn't have to take out of his jeans and give to the government. This can be seen as a stream of income to the landowner. This might serve the landowner very usefully in more advanced strategies. For example, let's say that $88,000 pays an insurance premium, and that funds the asset replacement trust I was talking about before. You see how this can be seen, this tax savings can actually be seen as something concrete, money that can be rededicated to other purposes in the estate plan that can help solve the problems. But let's say the landowner waits and the doctor makes the donation on January 1 of 2014. That's when the law is scheduled to change. Now, instead of a 50% AGI limit, he's left with a 30% AGI limit. So he's not going to get as big a bang for his buck when you run the numbers. He's limited to just over $300,000 in total tax savings because he can only push that unused portion of the deduction and use it for a total of 6 years instead of the 16. So the difference between making a donation in 2013 for this particular person and making a donation in 2014 is over $1 million. So for all of you who are working with landowners, this is some incentive to give to them. If the financial motivation is important, 2013 is the year where they're going to be sure that this deduction, these higher incentives are going to be in place. We don't know what's going to happen in 2014. Let's look at it from the federal estate tax point of view. We've already talked about these incentives. Here's the exclusion. This means that at death, when it comes time to calculate the federal estate tax that's owing, and you're valuing the property, the ranch, okay, and it's subject to the terms of a conservation easement, you can exclude an additional portion of the value when you're making that calculation. So here, I'm just going to use this example very quickly. It's the single donor, it's the doctor with the estate. In addition to the ranch, he had cash. And when you run through the numbers, the difference that using a conservation easement makes is quite substantial. The federal estate tax exposure before the easement was over $2 million. When you run the numbers after the easement, it drops down to less than $140,000. So this, again, is a tremendous incentive for certain landowners that are facing a federal estate tax liability that could be useful in your discussions with them to proceed with the transaction and save those tax dollars. The first document that the IRS sees, right, when the income tax 1040 is submitted, the first document that the service sees that notifies them that this transaction has occurred is this form, the 8283. This has to be filed with every charitable deduction where an easement is involved. And this form has changed in 2012. Land Trust should be aware of that. The service is asking for either an additional statement attached to this form to summarize the terms of the easement, or for the taxpayer to attach a copy of the recorded conservation easement. There are a couple of other minor changes in this form too, having to do with how basis is calculated. But the point is, don't use the old form. Use the updated form. If there's a transaction that was done in 2012, this is the form that should be used now, the latest form as of December 2012, when that deduction is reported to the service. We'll briefly talk about sales of a conservation easement in the 10 minutes that we have left. Allison?
Most of the discussion today has been about deductible conservation easements, and a lot of the requirements that we've talked about are specific to preserving that deductibility. But we want to let you know that there are conservation easements which are being purchased in Texas. Sources of funding include local entities, states, cities, and counties. There are state programs. We need to get our state program funded better. Everybody, please include that in your prayers. And federal programs. I'm working in particular on the City of San Antonio's Aquifer Protection Program. It's a fantastic program which has been renewed by the voters 3 times, funded by a very small 1/8 of a cent sales tax increase. If you're interested in reading more about this, we have a series of success stories. This is one that's on the back table, but we have quite a few on our website, and they'll tell you stories about people that sold conservation easements. And anytime you're interested in trying to find funding, I encourage you to do an assessment internally about what the natural resources are that are important to the property, and think about what type of governmental entities are interested in protecting that resource. As an example, where I live in San Antonio, we are protected in some ways by the San Antonio River Authority, and this is their geographic service area. So if I had a client in this area, they would be a good source of funding to approach. Okay, we're going to tell you a success story or two, and then you're going to hear from landowners that have lived to tell the tale.
So this is a client of ours, Joyce Lucas, and Joyce had pieces of an estate plan together when she came to us, and she was interested in passing the ranch to her heirs. That's why she set up a limited partnership for them, and giving interest in that limited partnership to her daughters was what she wanted to do. But again, this was one of those cases where she was afraid that children would be likely to sell the ranch, so she wanted to protect it with an easement, and that's what we did for her. But as part of that process, we went through and changed many of the other elements of her overall estate plan so that it would fit in, the easement would fit in with the rest of her planning. And that's the takeaway from this story. An easement is a very powerful estate planning tool. It does a lot of things for the landowner. And if a landowner does an easement, then whatever planning that they had in place is going to be affected. And so this is a wonderful time to tell the landowner, you know, you're doing a very important transaction here. It's going to have these implications. You might want to go back and revisit your estate plan again and make sure that it's coordinated with this huge gift that you've made, or this big transaction that you've had. Here's a great story about the sale of a conservation easement. This was a client of ours, Gay Dahlstrom. Some of you have heard this story before. This is in Hays County, a 2,200 plus acre ranch. It had a huge quarry that cut through the middle of it. And this was one of the challenges to this particular situation. That quarry was important to the family because it was a source of income for the family. They needed to have that mining operation continue. At the same time, because of her age and because of the value of this property, it's right on 967 across where new schools were being built. It had the development potential for maybe 2,500 homes. There was this massive federal estate tax liability that she was facing. And so one of her advisors says, well, why don't you donate an easement? And she said, well, if I would do that, there'd be war in my family because my children look to this land for their financial security. There has to be some way that we can sell an easement in this case because I need to make peace amongst my heirs. And That's the situation that we set up. So she also, very unusually, had a desire to share the ranch with people, and she's made a portion of the ranch available, if the details can be worked out with Hays County, for some limited public access too, especially because there's aquifer recharge features on the ranch that she wants people to understand. She wants school kids to see these holes in the ground and understand how their drinking water is affected. So in this situation, this easement was valued at almost $22 million. You can see that we cut the size of her estate significantly. And when we connect up the ownership of the property, placed it in a limited partnership, that provides additional tax discounts for valuation purposes. We essentially eliminated the federal estate tax for this person. And we gave them tens of millions, almost $10 million to use, to help the family plan in the future and provide a resource for the family. And the funding was provided by different sources. We partnered not only with Hays County, but with the NRCS and the Hill Country Conservancy. And we're able to, in the city of Austin, we're able to put together a package for this family in order to solve this problem. And as a result of that, the structure of this transaction, when they receive that cash, which would normally be the sale of a real property interest subject to capital gain tax, the donation completely eliminated that capital gain tax liability. So this was another one of those home runs that was a very satisfying transaction to participate in. The terms of the easement: no subdivision, limited building rights. The quarry was allowed to continue. It was placed under a separate non-deductible easement. So my point is here, whenever you see a property and there's a big problem with it, there's ways to get around those things. There's creative ways that can be applied to those situations to overcome whatever the liability might be and to actually turn it into an opportunity. That quarry in 60 years will serve as essentially a big rainwater recharge feature. So when floodwaters come down Onion Creek, they'll be diverted into that quarry. It'll get filled up and form a lake. Okay. And that's the kind of vision that I think is important in working with landowners. If you can demonstrate that kind of vision, generally they'll be very excited about these types of permanent restrictions on their property and really understand, not only for themselves but for the next generation, the benefit of doing this transaction. So you can follow us on Facebook or Twitter. And this is a great quote from Aldo Leopold, and I understand we're watching a documentary about his life tonight. And I think that sentiment is especially important in Texas. Thank you very much.